Hi, I'm Jonathan. I'm a lawyer in Queensland, and this is part of a video blog series designed to help you to represent yourself in the domestic and family violence courts in Queensland. Today I'm going to go through some of the terminology or the words used in domestic and family violence matters. Hopefully, having heard these words before and their meanings will help you to have a better understanding of what's going on and to be more comfortable when you go to court. So I have a list here. I'm just going to work through the list and talk about what each term means. First of all, the aggrieved. Well, the aggrieved is the person whom the order is designed to protect. The applicant is the person who is asking the court to make the order. It could be a police officer, or it could be the aggrieved if it's a private application. It could also be someone applying with the permission or the authorisation of the aggrieved, or it could be a guardian of the aggrieved or an enduring power of attorney of the aggrieved. The respondent is the person whom the order is against, or the person whose behaviour the order will be designed to modify or put conditions on. The respondent is responding to the application made by the applicant. The magistrate. The magistrate is the decision maker. In the magistrate's court, the judge is called a magistrate. You can refer to the magistrate as Your Honour in court. What is a named person and a named child? Well, when the court makes a domestic violence order protecting the aggrieved, the court can also protect a relative or associate of the aggrieved from associated domestic violence. And the court can also protect a child from being exposed to the domestic violence or experiencing associated domestic violence. If you are applying for a domestic violence order and you would like somebody to be named on that order, it's important to include details of how they have experienced domestic violence from that respondent in the past. That gives the court the evidentiary basis to come to the conclusion that it is necessary or desirable to protect that person. The police prosecutor is a police officer or a lawyer who works for the police who represents the police in court. The registry is like the office for the court, and they maintain the court files. That's where you file your documents, such as your affidavit, which is your statement, or your application. To file it means that you are formally placing it on the court file. Then the document gets served on the other party. In domestic and family violence matters, the initiating application and the orders get served on the respondent by the police. Other documents, such as affidavits or the evidence which you might file during the course of the case, gets sent to the other party by the registry. When we talk about domestic violence orders, we often talk about the standard conditions and additional conditions. The standard conditions are the conditions that are on every domestic violence order. To be of good behaviour and not to commit domestic violence against the aggrieved. Additional conditions might include things like not approaching the aggrieved or not approaching within 100 metres of the aggrieved, to not contact the aggrieved, or to not approach within 100 metres of a place where the aggrieved frequents, such as the aggrieved's place of work. An ouster condition is a condition that the respondent is not to approach where the aggrieved lives. Sometimes this involves the respondent having to move out of that home. When one of the parties needs to move out of the home because the court is making a domestic violence order, the court can make what's called a return condition. That is a condition where that person can return to the property to collect their possessions in the company of a police officer. In that case, they can only take the possessions which are agreed between the parties to be owned by that person. The police attending do not have the power to determine who owns what property. If there is a dispute about who owns what items of property, then you should get legal advice from a community legal centre or from legal aid or from a private lawyer as to how you can claim your entitlement to the property at that address. If you are responding to an application for a domestic violence protection order against you, you can consent without admissions. What that means is that you are not contesting or you are not arguing against the court making an order, but you are not admitting that you've committed domestic violence and you are not accepting any of the allegations in the application. It is not criminal to have a domestic violence order against you. To breach or to contravene that domestic violence order is a criminal offence. So, the effect of a domestic violence order is to make behaviour or actions that would not ordinarily be criminal offences into criminal offences. For example, if there's a domestic violence protection order in place, then bad behaviour towards that person could be a criminal offence, or domestic violence towards that person could be a criminal offence. Or if there are additional conditions in place, such as not to approach within 100 metres of the aggrieved, and you approach within 100 metres of the aggrieved, well, that would be a breach of the order. If someone makes a complaint to the police about the breach of a domestic violence order, and they consider there is enough evidence to charge the person, then that person will be charged with a criminal offence. The penalties for breaching a domestic violence order range from a fine to a community-based order such as probation or community service to a term of imprisonment or a serious penalty. The main factors that the court takes into consideration when determining the penalty for the breach of a domestic violence order are the nature and severity of the breach and the criminal history of the person who breached the order. When an application first goes to court, the court proceeding is called a mention. At the mention, the respondent can consent to the application, or the matter might be adjourned to another date. An adjournment just means putting off the application to another date. The court does not hear all of the evidence at a mention. If the respondent does not agree to the order, then the matter will be adjourned until the evidence has been prepared, and then eventually the court will have a hearing where the court examines the evidence and makes a decision about whether there should be an order or not. If the court is adjourning an application for a domestic violence order, then the court will consider whether to make a temporary protection order. The court can make a temporary protection order if it's satisfied that it's the right kind of relationship such that an order can be made and that domestic violence has been committed against the aggrieved by the respondent. That temporary protection order, or TPO, remains in place until the court makes a final decision about whether to make a final order or not, or somebody makes a variation application. Once a matter has got to the point where the application has been served on the respondent has indicated to the court that they are contesting the application, which means they are arguing against it, and the parties don't need more time for legal advice, then the magistrate may give directions. Directions are where the magistrate says the applicant must have their evidence filed in the court by a certain date. Then the respondent must have the respondent's evidence filed in the court by a certain date. And any subpoenas must be applied for by a certain date. And then the matter will come back to court for a review mention, and then a hearing date is assigned. A subpoena is where the court makes an order that a witness brings evidence to the court or appears in court to be examined. An example of a subpoena would be where the court makes an order that medical records be produced from a hospital, and then a party can rely on that as evidence that supports their case. A hearing is where the court considers the evidence and makes a decision about whether there should be an order and what the terms of that order should be. If everyone agrees, then a hearing can be done on the papers. That means that the magistrate reads all the material and listens to any recordings and then makes a decision just based on that. Usually though, a hearing is done with examination and cross-examination of the witnesses. Examination of the witnesses is where the parties ask questions of a witness. The witness sits in what's called the witness box, which is just a special seat inside the courtroom where they sit while they're asked questions by each of the parties. The court can order that an aggrieved, a named person or a child give their evidence by audio-visual link, appearing in court on a screen instead of having to get into the witness box. Well, this exercise has certainly made me appreciate how much jargon we actually use when we're talking about domestic and family violence court proceedings. I hope this information has been useful to you. I hope that it has helped you to become more familiar with the terms used, and then you can be more comfortable representing yourself in court. If you find this information useful, please subscribe to my channel. I'll be making more videos to help people to represent themselves in domestic and family violence court proceedings. Also, please leave me a comment and let me know if there's something else that you would like me to cover in these videos. Thank you, and all the best with your case.